Legal access to digital legacy. The digital era adds a new complexity to the human test of dealing with death. Loved ones once may have memorialized the departed with private rituals and a notice in the newspaper. Today, as family and friends gather publicly to write and share photos online, the obituary may never be complete. After Allison lost a long battle with the colon disease in Canada, the family wanted to access her digital remains, pictures, messages, and written poems on her social media accounts. But none of the services allow the family, or any others, to retrieve the passwords of the deceased. Their argument is that it would violate the social media user's privacy. Since then, the attempts to recover Allison's online life are beginning to fall apart. Attempts to guess or reset her passwords have been backfired. Some of the accounts have been shutting themselves down, where Allison's family used these accounts to communicate and share memories with more than 500 friends. U.S. and Canadian laws are mostly similar. They do not treat digital assets like physical ones that can be distributed according to wills. In 1986, Congress passed a law forbidding consumer electronic communications companies from disclosing content without its owner's consent, or a government order like a police investigation. Although that law predates the rise of the commercial internet, courts and companies have largely interpreted it to mean that the families can't force companies to let them access the deceased data or their accounts. Yahoo said, to ensure an account gets transferred at death, users need to provide consent and their account information in their estate plans. Microsoft said, we won't provide families with passwords or control of accounts, but with appropriate documentation, it will give next of kin the deceased's email on disks. Facebook stated that they will respond in a way that is sensitive to a family's loss and is consistent with applicable law, which limits a provider's ability to disclose data to third parties. To date, 5 states have passed legislation giving executors power over digital assets. Connecticut and Rhode Island laws cover only email, while Indiana, Idaho, and Oklahoma laws include social networking and blogging accounts. For the time being, the laws remain largely untested in court, and the question will remain whether or not descendants can retrieve deceased relatives or friends' cherished content that the deceased person has placed on social media. The internet seems like a scrapbook, and a memory book that is going to be there forever, but it isn't. It could all be gone in an instant, said Allison's sister.